All right. For anyone that I didn't talk to already, welcome. If you don't know, my name's Glenn Bates. I'm an attorney with Woods and Bates here in Lincoln. My information's on the screen there. We have a couple folks on the call with us from our office. We have Kate. We have, I think I saw April on there. I've got everyone muted at the moment. I'm going to try to get through the presentation, and the presentation itself probably only take 20 or 30 minutes, and then there will be plenty of time for questions if you have them. As we go, if you have questions, feel free to scribble those down, or Kate's looking at the chat. If you want to send a chat message, she'll compile those and ask me them when we get done, or we can have you unmute if you want to wave at us or raise your hand or whatever. We'll keep going. So we're going to talk today a little bit about estate planning basics, if you will, what that entails. I'm going to put my information back on the screen here at the end also. So we'll get that again. All right. So let's start with a definition. When we're talking about estate planning, what is your estate? So your estate consists of everything that you own, whether it be real estate, personal property, any trinkets, whatever it is that you own, bank accounts at the time of your death. And those are the assets, if you will, that are going to pass to your beneficiaries under either a will or a trust. So when we're talking about estate planning, what we're essentially saying is we're planning for our ultimate demise. What's going to happen to our assets? What's going to happen to those that we care about when we're gone? And how are we going to get those things to those people and take care of those people with the least amount of negative tax implications? Just a short roadmap today of what I want to go through. I want to talk first about what a will is, what a last will and testament is, what a will-based plan is versus what a revocable living trust-based plan is. So what's the difference in those, pros and cons of each? And then just go through some of the things that we talk about when we're drafting documents, when we're meeting with clients to talk about estate planning, what information we need to start that process, and what information clients need to be thinking about to get that going. Then shift gears a little bit to talk about giving away assets during your lifetime. Can you do that? And most certainly you can. But how we want to do that may differ depending upon what tax implications those have or what implications they might have for Medicaid purposes, long-term care planning. And then finally, I want to talk about powers of attorney, what those are, what they do, and why we think that those are important. So the first thing we talk about when we talk about estate planning is what's called the last will and testament. And that is typically we refer to that as a will. So that's a document that directs what's going to happen to a person's estate assets when they die. When a person dies, their will gets deposited at the courthouse, and that's typically the courthouse of residence where they live. So for me, I live in Lincoln, Illinois. My will would be deposited at the courthouse here in Lincoln. And then if I owned assets that needed to be dealt with, my executor that I've nominated in that document is going to institute what's called a probate proceeding in the circuit court here in Lincoln. So that probate process is the court process that gives effect to the will, and it gets the executor vested with authority to deal with the assets of the deceased. So that executor is nominated in that will, and that executor would, once appointed by the court, would be vested with authority to take control of the assets of the deceased. Their job is to protect those assets, to pay any debts of the deceased, and then ultimately they're going to distribute those assets according to what that will says. The will can do a lot of other things. Those are the basics of what it can do. It can create trusts if you want to after you're gone. It can nominate guardians for minor children. So who's going to care for those children when you're gone? Those types of things can all be done in a will. So that would be a will-based planning. Differentiating that between what we call trust-based planning. The trusts I want to talk about today are what's called revocable living trusts. And there's tons of different types of trusts. So there's irrevocable trusts, supplemental needs trusts, life insurance trusts. If you can dream it, there's a trust for it. So these are a specific type of trust, which is a revocable living trust. And what that means is somebody creates that while they're still alive. They fund that trust with assets that they own, and they retitle their assets in the name of that trust. And by revocable, it means that they can do away with it anytime while they're still living and while they're still competent. So they maintain control over the assets in that trust while they're alive. That trust is going to do several things also, just like a will. You're going to nominate a trustee who's going to be the person that's in charge of what that trust owns. Most typically, that's going to be the person that creates the trust to start with. And then we're going to nominate a successor trustee who's going to step in if and when that original trustee can't act or after they've passed away. This type of planning does not negate the need for a will. We would still have a will if we had a revocable living trust, but in this revocable living trust type planning, that will is likely going to be what's called a pour over will. And in that will, what it's going to say in essence is, I leave everything I own to my trust. So that will is going to act as a safeguard to make sure that everything gets to the trust in case we haven't retitled our assets appropriately. And I'm going to get into that a little bit deeper here in a minute. But if we do this correctly, what this type of planning does is it avoids the need for a probate proceeding in the court, like we discussed earlier. And it avoids the need, hopefully, for the executor to have to do much to get any of the assets transferred to the beneficiaries. If assets are owned individually by the deceased and we have to use that pour over will, we're essentially adding a step. So we want to try to avoid that if we can by funding the trust with what we own and having the trust own everything moving forward. So like I said, there's pros and cons to each one of these. I'm going to go through those. But before we get to that, I just want to give you another definition, and that is intestate. So if somebody is said to have died intestate, that means that they died without a will and that their assets are going to pass according to the laws of the great state of Illinois. So that may, or more likely may not, be what you want to have happen to what you own when you die. There are default rules in the statute, and it says, if you don't have a will, this is what happens. In my case, half of what I own would go to my wife and half of what I own would be divided among my children, which again, that's not necessarily what I want. So I have to specify in some sort of planning document something different. Okay, so this chart helps us see, illustrates for us what the pros and the cons are of each type of plan. So on the left here, we have a last will and testament or a will-based plan. And then on the right, we have the trust-based plan, and it's divided into two sections. So this first section here talks about while we're living. So in a will-based plan, while we're living, the cost of setting that up is a little bit lower. And one of the reasons that it's going to be a little bit lower is because the time commitment for doing it is less. When you have a will-based plan, what you're saying essentially is, executor, here's what I want you to do after I die. So there's not a lot of time commitment there in that type of plan. Will-based plan does not delegate any control of your assets during your lifetime. You maintain ownership, you maintain control. If something happened to you while you were still living, nobody else is vested with any authority through a will to deal with your assets. It's not until you have passed away that the will becomes effective. In the right side here, the trust-based plan, there is some higher cost up front to create that. And one of the reasons for that is because there's an increased time commitment for doing that type of planning. But one of the things that I mentioned earlier is we want to make sure that trust is adequately funded, that we take our assets and we transfer those to the trust. And that can be done in a lot of ways. One of the easiest examples is I go to the bank and I take my bank account that's in my name and I retitle that in the name of my newly created trust. Or I do a deed for my real estate from me to my trust. Now my trust owns that. And so now my trustee of that trust can deal with those assets. One of the advantages of this type of planning is control of assets if you were to become disabled while you're alive. If you are acting as a trustee in that case, your successor trustee would be able to handle the assets that the trust owns. So there is some easier succession of control in a trust-based plan. So then we look at after death, if we shift back over to the will-based planning, as we discussed, there is court involvement in that type of plan. So that will gets admitted to probate. The probate court is involved in that. The executor gets appointed through orders of the court. There's a higher cost after death because the work then is going to be done after the person has passed away. It's going to be more time consuming not for the person that created the will, certainly, because they're deceased at that point, but it's going to be more time consuming for the executor. They're going to have to go through that court process. There's notices that are required to go out to beneficiaries, to creditors, things like that. One of the potential negatives in a will-based plan versus a trust-based plan is there could be some delay in getting the executor appointed. So it is a court process. That executor is not really vested with any authority until they get what's called letters of office from the court. So there's petitions that are filed, orders that are entered, and then the clerk would issue those letters. I will tell you that delay where we live is certainly not too much of a hassle. Most of the time, it takes a week or 2 weeks to get that done. So it's not a huge delay. You get up into counties like Cook County up in Chicago, that delay can be horrendous. Months could pass before that executor has access to those assets. So bills could come up. That could be a definite negative in some places. The last one, pro or con, whatever it may be with a will-based plan, there is no privacy with that type of planning. When we institute that court proceeding, that is a public record. Anybody that would be so inclined could go look at those documents and they could see what's happening in that case. If we go to the right side here after death, the Revocable Living Trust-based plan, there is no court involvement. I don't want to sit here and tell you there's never court involvement, because if, for instance, beneficiaries start arguing and litigating, there could be court involvement, but we hope 98% of the time there won't be. One of the reasons there's no court involvement is because the successor trustee is automatically vested with authority to deal with what the trust owns. That document is what gives them authority. It's not vested by a court, it's vested by the trust itself. If we've done everything appropriately with our funding and transferring of the assets, we hope there's minimal cost in the administration of the trust. We hope there's minimal time commitment for the successor trustee. There's no delay as long as it's properly funded, and trusts are private documents. So the only people that would be involved in a trust administration would be beneficiaries of that trust, the successor trustee, and then if there's any creditors, they would be involved or interested parties as well. So with all of these types of plans, whether it be a will-based plan or a trust-based plan, one of the things that becomes really important is ownership of assets and beneficiary designations. So how those things are owned and whether or not they list beneficiaries is really important. And it's important because those ownerships, those beneficiary designations, whether it be a transfer on death, payable on death, those all take precedence over what a will says or what a trust says. For example, if I draft a will and I say I want everything I own to go to my wife when I die, but I have a life insurance policy, and on that life insurance policy, I have listed my sister as the beneficiary. When I die, my sister is going to be paid whatever the death benefit of that life insurance policy is. So the plan that I've created didn't work the way I wanted it to because my beneficiaries didn't line up with what my plan was. My plan was that I wanted my wife to get everything. So when we're looking at these joint ownerships and these beneficiaries, transfer on death designations, we're doing that to make sure that the assets and the ownership of the assets, beneficiaries, things like that align with what the plan is to accomplish the goals that we set out to make the plan in the first place. These are important to keep in mind, not only when you're creating the plan, but they're also important to keep in mind as time passes, because as time passes, we all know things change, life circumstances change. We have things like death, birth, disability, divorce. All these things can affect the initial plan. So we think it's important to make sure the assets align, but also to review those from time to make sure that we're still lining up with what we want to do in the plan and that the plan still says what we want. Great example would be divorce. If we have a former spouse that's a beneficiary of a life insurance policy, that's a bad deal. Not for the former spouse, but for the plan, certainly. So when we talk about these types of assets and ownership and things like that, one of the considerations when we are planning is, do we need to plan for estate tax, or is there an estate tax issue? This has changed over the years. Sometimes people refer to it as death tax. We do not have an inheritance tax anymore. Some states do, but in the state of Illinois, we have what's called a estate tax. There's a federal system and there's a state of Illinois system. So in the federal system, there's an exemption amount of $13.6 million per person. And if the total value of all of the assets of the deceased is less than that amount, that estate is exempt from estate tax in the federal system. There's no tax due. If it's above that amount, then there's tax due. In Illinois, the exemption amount is, the system is similar, but the exemption amount is lower. So the state of Illinois has an exemption amount of $4 million per person. If the total value of the estate is over that, then there's an obligation to file an estate tax return and pay a tax potentially. But when we calculate that gross taxable estate, we're talking about everything. So this chart on the right side here talks about probate assets. Probate asset is going to be an asset that's owned only by the deceased individual, doesn't have any other joint owner, doesn't have any beneficiary, doesn't have any payable on death designation. It's just in their name. So those are going to be the assets that are controlled by the will, and in the absence of a will, controlled by the state statutes. Those will beneficiaries are going to be the ones that inherit those assets, or the heirs in the case that there is not a will. So that is different from what we refer to as non-probate assets. Those would be the things that we talked about, like joint owners. I own my house jointly with my wife, and that ownership has rights of survivorship. So if I die, she automatically owns that asset. There's no estate that has to be probated. There's no documents that have to be filed. It's automatic by operation of law. She owns that. That would be the case with anything that I own jointly with anyone else if I passed away. Same deal with beneficiaries. So those beneficiaries are going to get paid automatically if they're listed. And if a trust owns assets, then the trust beneficiaries are going to be the ones that inherit those assets. So those would be non-probate type assets. When we're talking about estate tax, we're talking about everything. So we total up the value of everything, whether it be a probate asset or a non-probate asset. And then we see, is that going to be above or below the exemption amounts? Do we need to file an estate tax return and pay a tax? And that's the process we go through when we're planning also. And we see, do we need to try to limit estate tax? Is there something that we need to do in this particular situation to make sure or try to reduce that value? And we do that by compiling a list of assets to look at them and see, okay, here's the total. Are we above it or are we below it? And then go from there. In addition to the estate tax consideration, when we're meeting with clients or we're talking about creating an estate plan, we need to try to figure out who, what, or where do we want our assets to go? Do I want individual beneficiaries, kids, spouse? Do I want some sort of entity to inherit? Do I want my assets to go to charities? And then along with that, do I need to protect these people that I'm leaving assets to from themselves potentially? Do I have a beneficiary that I know has capacity issues? Are they minors? Do they need to have somebody handling these monies for them? Do they have special needs? Are they going to need some sort of special needs trust? Do they have addiction issues? Is a large inheritance going to negatively affect them instead of be beneficial to them? So those are the things we were thinking about. And then who do we want to act in the positions that we talked about earlier? So who do I want to be my executor? Who do I want to be my trustee? In a second, we'll talk about powers of attorney. Who do I want to be my agents? And if those people can't act, who's going to step in and take on those roles? So we think it's a good idea to have at least one successor nominated, so that if I've nominated my spouse and we're in an accident together, then somebody else is able to step in and take on those roles. And I've made it clear who I want those people to be. Again, who do I want to care for minor children? If I have minor children, this can be important. This is sometimes a difficult decision. State of Illinois differentiates between guardians of the estate and guardians of the person. So a guardian of the estate would be who's going to deal with financial related matters for that minor child or that disabled person. Guardian of the person is going to be who is going to care for these minors, in this case, on a day-to-day basis. So who's going to do the things that I'm doing now as the parent? Who's going to take them to school? Who's going to feed them? Who's going to hound them to shower and brush their teeth every day and make sure they're doing all those things that kids complain about doing? In Illinois, if it's not designated otherwise, a minor inherits, they can't hold those assets, but somebody would hold them until the age of 18, and then it would distribute to them. If we don't want that to happen, we don't want to have them get a windfall at age 18, we can specify that the guardian should hold those assets until 21, but that has to be in writing. And if we want someone to hold those longer than 21, that would be when we would start looking at creating a trust. So the trustee would hold those until they're 30 or 35, or in some cases, if there's a disability, it would be potentially for the lifetime of that person. Who's going to act as our trustee? And then finally, do we want to make any specific bequests of property? Or do I want something that I own to go to someone specifically rather than generally? I want my gun collection to go to my grandchildren. We're making sure that we're putting enough specificity in there to make sure those bequests happen, make those gifts. So that's all what's going to happen when I'm gone. Now, what's going to happen while I'm still living? Because things can happen while I'm alive also, or maybe I want to give some things away. And you can certainly do that. Anything you own, you can give it away. You can give it to charity. You can burn it. Whatever you want to do with it, you can do. But there are some potential issues with that if we're giving gifts. The rules as they are now say that any individual can give to any other individual in a calendar year an amount not to exceed $18,000. And then if it doesn't exceed that amount, there's no requirement to file a gift tax return. So if the gift exceeds that amount, the IRS says you need to file a gift tax return that documents that gift. There's not necessarily going to be any tax due with the filing of that gift tax return, but what it might do is it might create some unintended consequences. If we're filing that gift tax return, whatever the value of that gift is that we've given comes back into the estate when we're talking about calculating the gross taxable estate. So if we've given a large gift for purposes of estate tax, we have not necessarily divested ourselves of that amount. So that's where that $18,000 becomes important if we're trying to reduce the value of the estate by gifting. A couple other things to keep in mind when you're making gifts is that a recipient of a gift is going to take the tax basis of the person that's giving the gift. That can become important if the recipient of the gift were to turn around and sell the asset. For instance, somebody gives away a piece of real estate. They have a relatively low tax basis, and that real estate, their tax basis would be either the price they paid for it or the value on the date that they inherited it. They give a gift of that piece of property. The recipient turns around, they sell that piece of property. That recipient's going to have a fairly substantial gain because the gain is going to be the difference in the sale price and the tax basis. And then that recipient's going to have to pay gains tax on that value. That's different than if that recipient would have inherited it through either a trust or a probate process. They would get a step up in tax basis to the value at date of death. So that's an important consideration. As a somewhat aside of this, gifting can create some ineligibilities with Medicaid. This $18,000 threshold is out the window when we start talking about Medicaid. Medicaid would be worried about any gifts that you've given within the look back period, which they say is 60 months. Within the last 5 years, if you were to need long-term care and you needed to apply for Medicaid, they would ask you, have you given any gifts in the last 60 months? And if the answer is yes, then the value of those gifts create an ineligibility in that amount. That ineligibility would have to be made up before Medicaid would kick in and pay for long-term care. That's a really complicated area, and I'm not going to delve too deeply into it today, but that could probably be a presentation in and of itself. So the last thing that I want to talk about today is powers of attorney. And these are documents that we think are important and that we wrap up in the discussion of estate planning for a couple reasons. But one of the main reasons is because with these documents and with any of the documents we've already talked about, the person that's signing these has to be competent. So they have to know who they are, where they are, what their assets are, who their beneficiaries are, who their children are, things like that, in order to be able to sign these documents. And what these documents are going to do is they're going to appoint an agent to act on behalf of the person signing them in either the event, I say convenience or necessity. So there's two documents that we use. There's a property power of attorney. And convenience under that document would be, agent, I need you to go transact some business on my behalf because I am out of the country. So that would be convenient for them to do that. Necessity would be if the person that signed the document becomes disabled or is in a coma or something like that, the agent can use that document in order to handle the business of the person that's disabled. Power of attorney for property is just what it sounds like. That agent would be able to handle the finances, do all the property related matters of the person that signed that document with the power of that document that they've signed. The healthcare power of attorney is a little different. That's appointing an agent to deal with doctors, hospitals, medical records, things of that nature if the person can't make those types of decisions for themselves. So if they become disabled or in a coma and they're not able to communicate with the doctor, that agent would be able to do. We wrap up in that document what is sometimes referred to as a living will or used as a different separate document. And that document will make life-sustaining treatment decisions. So whether or not you want to be kept alive by artificial means, if you do not, who you want to make those types of decisions if and when that time came. Again, you have to be competent to sign those, but we think those are really important. Once somebody passes away, those documents, those power of attorney documents are revoked. And then we would look to a will or a trust to see, okay, here's what's going to happen next. Okay, so in summary, I will say that everyone on this call, everyone in general, circumstances are different. Each estate plan, we believe, needs to be specifically tailored to the client's needs, to the client's goals, to what they want to have happen. One person may say, I want to give everything I own to charity. That makes the estate tax issue a non-issue because everything is going to go to a charitable entity, so we don't even need to worry about that. Somebody else may say, I want everything I own to go to my spouse, may negate the estate tax issue also. If I want it to go to my children, that could be an issue. It just depends on what the person wants to have happen. And we think that it's good to review these types of plans at least annually to make sure they still say what we want them to say. They're still going to do what we want them to do. And that we make sure that anything that we have in the interim is lined up with the plan itself. I think it's important that people make their wishes known while they're living. It avoids confusion. It avoids feuding. Confusion and feuding equals lawyer fees. Lawyers are the only people that win when we litigate estates. I will tell you that against my own self-interest, but it's the truth. I think it's something that is not a fun discussion, certainly a lot of the time, but if you're sitting down with your loved ones and you're saying, okay, here's the plan that I've created. Here's why I've done this. Here's what's going to happen. Here's what you should expect. I think it limits the anxiety when it actually happens. It limits surprise. If we all know and are on the same page ahead of time, we're not going to be shocked when the time actually comes. So I think those types of discussions are valuable. We have plenty of time for questions. If you do have questions, or if you want to sit down and talk about your individual situation, we're more than happy to do. Give us a call and we will schedule a time for you to come in and meet with one of our attorneys. Our information's there on the screen. Actually wasn't following the chat, but if there were questions, we can field those now, and I will unmute you if need be. I think you should be able to unmute yourselves, but if not, just wave your hand or raise your hand and we'll get to you. Kate, were you able to unmute yourself?
I was, yes. So I have a question. Could I write my own will?
You could. There's a lot of states that allow you to write your own will as long as it's in writing and signed by the person that wrote it. That's valid in a lot of states. In our state, that is not a valid document. So even if you do write your own will and it's in your own handwriting in Illinois, that document still has to be following the formalities of a last will and testament in order for it to be valid. So not only does it have to be in writing and signed by the person creating it, it also has to be witnessed by two uninterested people. So those are some of the formalities that we make sure are being met when we're drafting wills. When you get into do it yourself, sometimes it gets botched and then causes even more problems later on. But you can write it yourself. It just has to follow the formalities. It can't just be a holographic will that you have written and signed in this state, at least.
Go ahead, John.
Thank you. My question is, you talked about the revocable trust, and I know you said there's like a lot of trusts, an irrevocable trust. Does that, in that particular instance, you lose control of your property or what have you? Am I right in that, or that's a very simplistic question, but.
No, I think you're on the right page. That's one of the negatives of an irrevocable trust is you're giving up control at that point. So if you were to create an irrevocable trust, and there's reasons to do it, but if you conveyed assets to that irrevocable trust, it's just what it says. It's irrevocable. So you would not be able to change your mind. You're not really going to be able to change who the beneficiaries of that trust are, things like that. So you're creating that trust and you're saying, all right, trustee, here you go. I'm done with this. That was something that was, I don't want to say it was popular, but it was somewhat in vogue back in 2011, 2012 timeframe for people that were trying to limit the value of their estate for estate tax purposes. So they would transfer assets to an irrevocable trust. And what that did was it solidified the value on the date of transfer. Okay. So they said it's worth X, it's worth $1 million at the date of transfer. It locked that in. So then when they died, that $1 million is what would have come back into their estate when you're calculating the estate tax. And if it worked appropriately, the thought was that asset's going to appreciate in value over that time. And that appreciation is not going to be included in the estate because they've divested themselves from ownership. Sometimes that works and sometimes you look like a genius. Sometimes it doesn't work and you look like, oops. But yeah, I think the very simple answer to your question is yes. All right. Ben has a question.
Yeah. So my question is, it's two a little bit. My wife and we're young. We're in our early 30s. We've got one young child. So is there a certain type of trust that would be best for us? And then also along with that, if we wanted to put property like our home and stuff in a trust, can you still do that if it's mortgaged at the time, if you want to do a trust? And like with our life insurance policies that we have, can you put that in a trust as well? Or would those just designate like beneficiaries?
Probably the easiest thing to do with the life insurance would be to list your newly created trust as the beneficiary, and then it would pay out to the trust at death. You can also change the ownership of those, but I've found that it's easier to just change the beneficiary because that's a much simpler process. The mortgaged house issue, I think the short answer is yes. More complex answer would probably be, I would tell you to contact your lender before you did that so that they're not seeing a transfer happening without getting their mortgage paid off and don't call your mortgage due, but that's usually not an issue, because you're still going to, in the revocable living trust, you're still going to basically have control, and you're still the one that's going to be responsible for those types of debts. So you're not really giving up any of that control with that type of trust planning. I think the revocable trust could be certainly beneficial for minor children. And what that would do is, if you created it during your lifetime, it's already going to exist when you die. So you wouldn't have to necessarily have somebody create it later. Your trust would be there. Your successor trustee would step in, and the successor trustee then would have control of all the assets that trust owns. Did I remember the questions correctly there?
Yes. Yep. You did. I think that, that covers the questions I had. Thank you.
Looks like we have a question in the chat. What is the approximate cost to have a will drawn up legally and the cost to set up a trust initially?
I would say, as a rule of thumb, it would depend upon complexity of the documents and the individual situation. But just as a ballpark, I would say for a will-based plan, around $1,000. And then for a trust-based plan, probably $3,000 to $4,000 would be a good estimate. We're going to know that. So just FYI, if you called our office at least and you called to schedule an appointment, one of the things that's going to happen first is we're going to send you a link to a portal where we can share information, and that has some questions that we ask you to go through and answer to gather some information about your situation. So it's going to help you organize that information and get that all together to give us the information we need to competently talk to you about the things that I've talked about today. So we're going to look at that ahead of time. And then when you come in and sit down, we will talk about, do we need to worry about estate tax? Who do you want to inherit? That's all the things that we talked about today. And then when we decide here's the best course of action, or here's a couple courses of action, we'll be able to tell you this is what this is going to cost, or this is what this is going to cost at that time. And you'll know before you tell us to start working what the fee is going to be. That's our office. I don't know that's universal, but that's how it would work here.
Glenn, I don't know how to raise my hand, but I have a question. And first of all, thanks for putting this on. We learned a lot here in this brief time. Our kids, one is married, the other will soon be married. Is there any difference between the will and the trust as to what the spouse would inherit in the event that we're no longer here?
Spouse of your child, you mean?
Correct.
So the spouse of your child is not going to inherit from you unless you've named them as a beneficiary in your planning document. So if you've named them as a beneficiary, they would inherit. They're not going to inherit just by way of being your daughter's husband, for instance. But if your child inherits from you, that spouse then in turn would be entitled to a portion of their estate if they died. Okay. So if you were, and I'm not saying this is your situation, but if you were concerned about your child's spouse having or getting assets from you, ultimately, the trust would be a better way to go, because you could hold those assets in trust and protect them from your child's spouse inheriting. It's when the child comes into ownership, if they inherit outright, their spouse is going to be entitled because they now own the assets. Does that make sense?
Yeah. Yes. Yeah. And my fear, they inherit everything we have, we worked hard for. A year after the inheritance comes to my son or daughter, there's a divorce in that situation.
That was going to be my next point, is that trust could protect those from that situation also, whereas an outright inheritance would not.
Gotcha. Okay. Very good.
A trust is going to act as a barrier, and it's going to be, here's what's owned by the trust, and those are not going to be accessible either through the estate or through the divorce when that person dies or is divorced, because they're owned by the trust and not them individually.
Very good.
On the heels of that question, I'm sorry, I'm not going to try to hog the conversation, but that keyed something. in the event that there is a trust where there's a considerable, whatever, there's a sum of money and there were to be a divorce, the spouse then can in no way say they're getting $10,000 every single month. How do I think that I should be entitled to that. They can't in the divorce try to get any of that property or any of the what have you out of the trust. Am I correct?
Yes and no. So I think in the example that you just gave, any of the income that the beneficiary is going to be taking will likely be considered in a divorce situation when you're talking about potential maintenance or child support or those types of things. I would think that the court would take those into consideration. Now, I say that with a grain of salt because it's probably been 12 years since I did a divorce case. So I'm not sure on that, but my gut feeling would be that would be considered income to that person. The court, I don't think in that scenario is going to care where it's coming from. But what would be protected in that situation would be what's the principle of the trust. So what are the assets that are earning that income? Those are not going to be the subject of the divorce because those aren't marital property. Those have been kept separate. Those are held and owned by that trust, and that child really doesn't have access to them. Now, that is not going to be the case if you're the one that created the trust. So in the divorce situation, if you're the one that created the trust, those assets aren't going to be protected from a divorce. It's only going to protect it for your beneficiaries. Good questions. Anybody have any other questions?
How difficult is it to make changes to your will or trust?
Anymore, it's not too difficult. Back in the typewriter days, it was a little bit more difficult, but with word processing, it's not that big of a deal. So if you were going to make a change to a document that you've already done, that we've already drafted, more than likely, if it's a will, we would probably just draft a new will with the changes and have you sign the new will, which would revoke the old will. What used to happen a lot was there was what's called codicils to the will. And that was just to make sure that you didn't have to retype the original document all the time. Like I said, that's not a big issue anymore. I prefer just amending the document itself rather than having separate pages of codicils and things like that can get lost. So I think that's a better process now. With the trust, we do still do amendments to the trust if they're minor, but if they're major overhauls of the trust, we'll just redo that document itself also and revoke the old one. So those are not complex things anymore. You can change it as much as you want, really.
I heard during the presentation that you recommend doing it annually.
Yes. So I don't know that you necessarily need to revise them annually, but I would say at the very least, pull them out of the drawer and look at them at least annually and make sure that when you're updating your asset lists and things like that, everything is still in line with what you did when you did the plan. Just the other day, I had some documents that were done, I don't know, it's 25 years ago now. And a lot of things had happened. The provisions of the documents talked about minor children and trust for minor children. And those people are now well into their 30s. A lot of that is not applicable anymore. And as things change, documents should change too.
Then how long does the process take for the estate plan?
A lot of that's going to depend on the individual, but from the time that somebody calls to make an appointment, from the time that they're sitting down and signing documents, I would say 3 to 4 weeks would be pretty good guess, pretty good estimate. Some of that's going to depend on availability of everyone to sit down. But when we meet with people, we will usually come up with, here's what we want to do. We can get those documents drafted and we will send out draft documents to review in some way, shape, or form. And then we'll ask people to give us a call and discuss questions. Because a lot of times when I'm sitting here talking about this abstractly, even in this format where I've got PowerPoint slides and things, it is a little more concrete when you see the physical documents and see what the physical documents say. So then if we need to discuss questions or we need to change things or we've seen what it looks like and now maybe we want something a little bit different, we'll get those revised and then we'll set a time to have people come in and sign those documents, and then they'll take those documents with them and review those annually like good stewards. But I think a couple weeks tops. I didn't see any other questions. Couple thank yous. You are certainly welcome. I'm glad everybody could make it today. If you guys do have questions, I'm happy to stick around for a few more minutes here.
We did have one come in. Do you pay per appointment or is that at completion?
So we will come up with the plan for what we're going to do and what the price for that's going to be. And we'll ask that be paid at that time. And whatever time it takes to do that, it takes to do that. We found that to be a little bit more transparent way of doing business than by appointment or by time. All right. Thanks again, everybody, for coming. Got you out of here 5 minutes early. You can go to lunch early. We'll talk to you soon and let us know if we can help.
Thank you.
You bet.